to the Fin Talks, a chat with Finance Malta. Our guest today is Geoffrey Bezzina from the Office of the Arbiter for Financial Services. Geoffrey, would you like to introduce yourself?
Hello. As you said, I come from the Office of the Arbiter for Financial Services in Malta. The OAFS is an out-of-court dispute resolution mechanism for financial services consumers. So this is a setup which reviews, investigates and adjudicates complaints lodged by customers against financial services providers licensed in Malta in regards to any aspect of financial services. So it could be banking, investments and insurance.
Okay, and can you give us a little bit more of an overview of the work you do and how the office is set up and what the day-to-day ongoings are?
Sure. We are a relatively young agency. We are set up by law. Mm-hmm. We were set up in 2016 by Act number 16 of the Laws of Malta. That will be Chapter 555 of the Laws of Malta. The law came into force on the 18th of April 2016. And we hit the ground running because we were asked to set up this new setup as quickly as possible. And indeed, by the end of May, we started accepting complaints from eligible customers. Our offices are currently now housed in Floriana. And our setup is an out-of-court dispute resolution mechanism. So let me explain why it is out-of-court and a dispute resolution mechanism. First of all, our law is based on a European Union directive, Directive 2013/11, which is the Consumer ADR Directive. So when you hear me mention ADR, it's an acronym for Alternative Dispute Resolution Mechanism. Right. Now, why is this setup important? If you had to look back a number of years, the European Commission pushed towards alternative means for consumers to have their complaints reviewed, handled outside of the courts. Okay. So when you have a dispute, you would normally say to yourself, okay, if I have a dispute against an entity, a bank, a company, anyone, I have to go to court. Yes. But really and truly, now there are alternatives to the court. Mm-hmm. I would say it's an alternative to the court. It's not a replacement to the court. Mm-hmm. So if a consumer has a dispute, he or she may not refer the case to us, to the Office of the Arbiter for Financial Services, but he or she may refer the matter to the court directly.
And how does so your role is kind of an ombudsman, ombudsperson?
Okay, an ombudsperson. That's a setup. Yeah, no. It differs. That's the name. That's a technique in the way a complaint is handled.
Right.
Now you've got different techniques as to how you can manage or listen or review a complaint. Mm-hmm. In fact, you can have conciliation, you can have mediation, you can have arbitration. Then there is the ombudsman model. Mm-hmm. And the arbiter is another name for this extrajudicial out-of-court dispute resolution mechanism. Mm-hmm. We do not form part of the court.
No.
Okay. However, decisions which are delivered by the arbiter can be appealed to the court. But I don't wish to jump the gun here, okay? So our setup is based on the ADR directive, mm-hmm. okay? We handle any complaints relating to financial services against financial services providers which are licensed by the Maltese regulator.
Right.
Therefore, if a consumer has a dispute against a license holder licensed by the MFSA, a financial services provider, licensed by the financial regulator in Malta, yes, we can handle that complaint. However, as you know, financial services is also on a cross-border basis. So we also make use of products, purchase products or services of a financial services nature from entities which may not necessarily be licensed in Malta.
Right.
In that case, we cannot accept the complaint. However, given that we are part of a European network called FinNet, we would usually inform the consumer that he may refer the matter to our counterpart, another ADR in the place where that bank or that insurance company or that investment services provider located in the EU would be responsible for handling that complaint.
Okay.
Okay.
So there is redress for if someone buys a financial product on an app and that's not licensed in Malta, that you can guide them anyway.
Yes, and that is what we have done, for example, in regards to a number of products or services which Maltese consumers have purchased cross-border via an app. Okay. We have provided them with contact details of the ADR entity and any other EU. So in that regard, we are of assistance in some way or another.
Okay. Can you talk us through the processes, the different process for resolving complaints that you employ?
Sure. So, first of all, we have two processes. There is the informal process and there's the formal process. Okay, when it comes to the informal process, so you can have consumers calling us or sending us an email or using our website to submit an inquiry, to submit a minor case. For example, you could have a consumer having a problem contacting her bank in regards to a payment which has gone astray. Okay? You can have a consumer who has an issue with his insurance company in regards to the delay of the payment of a claim. You can have an issue by a consumer in regards to an investment which may have lost value and he is not receiving any information from the license holder. Okay? So we might be able to help informally. Okay? We can give information there and then, or we may refer the case informally to the respective institution. So you've got officials, usually it could be the compliance officer within the financial services setup, or it could be a department specifically expecting or managing or administering any inquiries which they receive from us.
Right.
Okay?
Within the financial services firm that
That's right.
the customer is complaining about.
That's right. So we try to informally resolve the matter.
Okay. So you don't you take that upon yourselves. You don't tell the complainant. No. Okay, go and speak to this person.
We may not. Why? It depends, because sometimes some consumers would prefer to pick up the phone, call us first rather than the bank.
Yes, when it could be resolved by a simple phone call.
That's
to the
right.
bank.
Okay. Right. So we may also involve ourselves in minor cases.
Okay.
Give an opinion, which is not binding. Okay. It's a conciliatory, non-binding, advisory, providing information, breaking an impasse. Okay.
Yes.
So it's very informal. If many of the inquiries that we receive, we manage to, help out the consumer. But there are some cases where the consumer might not get the answer that he was expecting, for example. And then we would inform him, please, now you can proceed to the formal process.
Right.
And there is a certain formality which the consumer needs to follow in regards to the submission of a formal complaint. Okay, so the law says that the complainant has to be an eligible customer, okay, a natural person or a micro enterprise.
Okay.
And then the financial services provider has to be licensed by the MFSA.
Yeah.
The complaint needs to have a detailed complaint description, the reason for the complaint, and the remedy that the consumer is expecting from once the mechanism or the process is exhausted. All right. The law doesn't say there has to be the submission of a complaint form.
Right.
But we have, of course, from day one, prepared a complaint form which assists the consumer to structure his complaint or her complaint. Now we've also got the facility for consumers to submit an online complaint. Okay, so the person can go on our website and lodge a complaint online, and also provide and upload documentation online. All right. And pay also, there is a minor fee of €25, which is reimbursable, and I'll explain this.
Okay.
Okay. So the consumer lodges a formal complaint. Okay. If the consumer is a Maltese consumer, the complaint has to be in Maltese. But if the consumer is non-Maltese, of course, the complaint has to be in English, because our two working languages are Maltese and English.
Right.
Now, there are a number of aspects which the consumer has to check or make sure that he has, for example, not submitted his case to any other tribunal, out-of-court dispute resolution mechanism, or the court.
Okay.
Okay. In that case, we would not be able to accept the complaint.
I see. Okay.
Most importantly, before coming to us, the complainant has to lodge a formal complaint with the financial services provider.
Right.
So the customer has to write to the financial services provider, allow the provider 3 weeks to submit a reply.
Right.
If the reply is not to the customer's satisfaction, or if the customer does not receive a reply, then he may proceed to lodge a complaint with us. Okay? That is where the formal complaint process starts. We register the complaint. We send the complaint with the supporting documents to the financial services provider, and the financial services provider has to submit a reply to the arbiter within 20 calendar days from the date of receipt of the complaint.
Okay.
Once we receive the reply, okay, we send the reply to the customer, to the complainant. In parallel, we invite both the customer and the provider to refer the case to mediation. So that is the first technique that we employ in order for a complaint to be resolved.
Right.
Now, mediation is an informal process, but it's also a confidential process. It is a process where there are two adults talking to each other and trying to reach a solution. Okay?
That's obviously if the customer is not satisfied with the response given by the provider.
That's right. Now, there might be an opportunity during mediation for the parties to agree. In fact, a number of cases have been resolved at mediation. First of all, mediation, there is also a mediator. We have an official who coordinates mediation and is a mediator and brings the two parties to discuss the matter.
Do you keep statistics on how many cases are closed when the financial services provider replies, or how many cases move to mediation?
Yes, everything is in our annual report, actually. Of course, we do not report on how those cases have been resolved.
No,
because
we just report the numbers,
because that is, after all, mediation. It is confidential.
Yes.
The parties may object to referring the case to mediation.
Okay.
And it is their right
What
to do
happens
so.
then?
Okay, then the matter is referred to the arbiter. So the arbiter convenes a hearing. According to our legislation, the arbiter is required to convene at least one hearing. All right? So now, after COVID, all our hearings and even mediation sittings are being heard virtually. Okay. It's a mechanism which works. Mind you, when we started in 2016, we held hearings also virtually, because a good number of complainants are foreign complainants. They come from anywhere in the world, for the simple reason that the service that is provided by the provider does not necessarily need to be in Malta, but even from Malta.
Right, it could be a
company which
who's domiciled here.
That's right, but offers its service via passporting anywhere in the world, okay, especially in the EU.
Yes.
All right. So that facilitates the way the investigative process of the arbiter is handled. So we are able to, the consumer, foreign consumer need not be in Malta to have his case.
And they're
heard.
not at a disadvantage by being overseas, because they are. The service is the same for them as it is.
It is. I agree. Now all our cases are being held virtually. Okay. We send them the link, etc. And that's a process which works and it's quite efficient. Okay, for everyone. The customer need not appoint a lawyer. He is not obliged, or she is not obliged to appoint a lawyer. Okay. Can
they if they want to?
Yes, they can. Okay. All right. But some customers represent themselves. Okay, so there's self-representation here. Now, there are usually 2 hearings. The arbiter would usually convene 2 hearings because there will be the opportunity for the second hearing for the parties to cross-examine each other, for the reproduction of documents. The arbiter is very strict, very disciplined with the way hearings are held, okay? So between the date of the first or the second hearing, there won't be a lot of time. It isn't a lengthy process, okay? So the arbiter also has powers to convene witnesses, for example, to ask for documentation, but after 2 hearings, then he can or he may ask the parties to submit a final statement of submission, okay? And then the case is put for a decision, okay? So the arbiter, Dr. Reno Borch, then when the case is put for adjudication, a decision is issued. Now, the decision is published also on our website.
Okay, so
it is binding on both parties. Let's start this way. It is binding on both parties.
Unlike the informal process where you're giving advice, that's not. That's binding.
Right. The informal process is not binding. It's advisory, information giving, breaking an impasse, putting, trying to resolve an issue in an informal manner. The formal process is much more formal, as I said. So there are exchanges of documents, witness statements, statement under oath, and what have you. Now, that doesn't mean that the parties would have to allow the case to be referred to the arbiter after mediation. Let me explain. During mediation, the parties may agree.
Yes.
So if they agree,
then
we will refund. The case is closed, and we will refund the €25.
I see. Okay. There's an incentive.
There's an incentive for the parties to agree.
Right.
There have been some cases where after the first hearing, the parties agreed for us to reach a settlement.
Is there an incentive? Because obviously that's the incentive for the consumer. Is there an incentive for the financial services provider to agree?
Well, it's always an incentive for the provider to agree, but there might be issues which are much more complex.
Right.
And they would prefer to have an independent and impartial third party to adjudge a case rather than the provider and the complainant to discuss the matter between them and agree. Okay? There could also be, it's also not only for the financial services provider, but it's also for the complainant who would prefer to have his case adjudged by the financial arbiter. Okay. Once the decision is issued, all right, the parties have 15 days to ask for any clarifications or corrections to the arbiter.
Okay.
If there are no requests for clarifications or corrections, now either the parties can accept the decision, in which case it will become binding res judicata, but the parties can also refer the case to the Court of Appeal inferior jurisdiction at the court. Okay? And that's another process in which we are not involved. All right? The case file is passed on to the court, and we're
And you said that the decisions are published. So
yes.
How does that? Are they published? What kind of detail is published?
Okay.
Because you mentioned it's obviously confidential. So
all right.
How does that?
Well, when I said confidential, I was referring to the informal process.
Right.
With regards to the formal process, the decision is published in full except for the name of the complainant. Okay.
So anyone who knows the case could...
Yes, but we remove the details of the complainant. We actually pseudonymize the name of the complainant, but we leave the name of the provider intact.
Okay.
Okay.
So that is part of the incentive
that could be
for the provider
there you are.
To mediate.
That's right. To
agree in mediation.
That's right. And then the case. So on our website, there's a section with all the decisions published by the arbiter. The decisions of the arbiter can be identified, or the user can search by the name of the provider, by the classification, whether it's rejected, accepted, or partially upheld. Then there is also the category, so the sector, so banking, investments, and insurance. And the subsectors, whether it's pensions, investments, or the type of service. So there's quite a lot of detail. And of course, they are published in the original language of the decision.
Yes.
Okay. Now we have also included also details as to whether that decision has been appealed or not. And we include the reference number of the Court of Appeal reference
so
number.
Who wants to follow the case can go then
That's
to
right.
the Court of
That's
Appeal.
right. It's either in progress, if it is not in progress, or in the sense that it has been adjudged. So there is also a reference in that regard. Now, the decisions, as I said, they are in the original language of the decision. However, our annual report includes case summaries of a good number of decisions which the arbiter issues. So if the decision is in Maltese, for example, so you would be able to find a summary in English in our annual report. So that is also a source of information for those who would like to know more about our work, about the decisions of the arbiter. It's also not only for research purposes, but also for compliance officer and financial services providers as well.
Okay, very good. And how does this fit in to the financial service providers' internal mechanism for redress? And is that an incentive for them to respond to complaints? How do the two work together?
Okay, that's a very good question. You are aware that all financial services providers are required by the regulator to have an internal complaint mechanism. All right, they have to keep a database of complaints, and they have to report to the regulator on a periodic basis the number of complaints, and they have to classify them in some way or another. But that's the regulatory aspect, the reporting of complaints or the reporting of statistics of complaints. But please keep in mind that a complaint is a source of information for the financial services provider, whether it is submitted internally or whether it is submitted against any other service provider, who may be in the same line of business as you are. Because, as you know, complaints can be a source of information to you. It can help you, assist you with the way you are running your business. Some may say, if I receive one complaint, I don't really give it that importance. Not necessarily. One complaint could open a floodgate of complaints. So it's very important to use intelligence, to use information from a complaint to do root cause analysis. What is happening? Why am I receiving so many complaints about this area? So that's one thing. Then when it comes to the decisions of the arbiter, that too is also a source of information. A source of information in the sense that sometimes you've got situations where the compliance officer or where the management would say, no problem, I followed the law. But do keep in mind that the arbiter adjudicates complaints not only by reference to the law, but also to what is, in his opinion, fair, equitable and reasonable in the substantive merits of the case. So you in the sense of the financial services provider, you might be following the word of the regulation.
Yes.
But you might not be following the spirit.
Yes, and you might not be treating customers fairly.
That's right. So
what is the fact that you're following the law?
Correct. So what is fair? What is reasonable? How should I be treating this customer in regard to this complaint? Not all complaints are identical.
Of course.
There are similarities. I would like to say also that the arbiter has the power in terms of the law to treat cases which are intrinsically similar in nature as a collective case.
Okay.
So there are a number of decisions which the arbiter has treated as a collective case. Right. For example, there was a case relating, they were submitted individually by complainants against the same financial services provider in relation to the same matters. So the arbiter decided or issued a decision collectively. All right. Okay. So it's very important for those who are in the sector, who are compliance officers, directors, management, and even employees. Of course, there is also the academic part, those who are still studying, to make reference to and analyze the decisions of the arbiter, because in some cases, the arbiter, I wouldn't say went beyond the law, but his interpretation was much more holistic than, for example, one would normally decide a case, okay? Yes. All right, than the letter of the law. So it's very important. You've got a lot of information in our annual reports and in the decisions, not only in the decisions issued by the arbiter, but even the Court of Appeal. So you've got also not only ombudsprudence, but you've got now also jurisprudence. Okay?
Very good. Thank you so much. One last question. How can stakeholders get in touch with the office of the arbiter?
Well, our first port of call would be the website. So our website, financialarbiter.org.mt, it's in Maltese and in English. Okay. Everything, what I have explained during these past few minutes, is everything explained in much more detail on our website. Consumers and providers can also get in touch with us telephonically or via email or via our website. And of course, our annual report is also a way to get to know more about what we do and our role within the financial services industry.
Thank you very much for your time, Geoffrey. And you can find this recording on all the podcast platforms and Finance Malta's YouTube channel. Thank you.